Hello Year 12s and welcome to this video on class actions. There are 4 things that you need to do while you're listening to this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. The third thing that you need to do is to have your vocabulary sheets open in front of you so that you can write in your vocabulary sheets the definitions of key terms or of any other words that you're unfamiliar with. And the fourth thing that you need to do is to have your summary books open in front of you. As we go through this video, I will give you some guidance as to what to include in your summary books. Once you've finished watching this video, please read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then make sure that you supplement your Cornell notes with that information. This slide sets out the learning intentions for this video. Make sure that you write these learning intentions down in your Cornell notes. The first learning intention is that you should be able to discuss the appropriateness of class actions to resolve a civil dispute. The second learning intention is that you should be able to evaluate the extent to which class actions achieve the principles of justice. A class action is a legal proceeding in which a group of 7 or more people who have a claim against the same person based on similar facts bring their claim to court in the name of one of the parties. The group of plaintiffs who bring the class action are called the group members. The plaintiff in whose name the class action is brought is called the lead plaintiff. Class actions are also sometimes referred to as group proceedings or representative proceedings. Look down the left-hand side of your vocabulary sheets, find the term class action and write this definition in there. Once you've done that, please highlight the words in bold red italicized type. And if you're ever asked to define or describe a class action, try to remember to include those highlighted words in your definition or description. A number of class actions arose out of the Black Saturday bushfires that occurred in 2009. These bushfires were caused by electricity lines swinging in a high wind and hitting each other, creating sparks which set fire to the surrounding bush. As a result of these fires, some people died and many more lost houses and other property. For each bushfire, a group of people who had suffered loss because of that bushfire brought a claim against the power company that owned the electricity lines. They argued that the power company had been negligent because it did not properly maintain the electricity lines, which meant that they had become loose and so could swing against each other in a strong wind, causing sparks. The claim of each of these people was against the same person, that is the power company, and was based on similar facts, that is, the failure by the power company to properly maintain its power lines so that, in a strong wind, those power lines swung against each other and sparked the bushfire. Each of these plaintiffs could have brought a separate action in negligence against the power company. However, that would mean that in each case, the plaintiff would have had to establish that the power company owed them a duty of care, that the power company had breached that duty of care by not properly maintaining its electricity lines, and that the plaintiff had suffered loss. In a class action, the claim is brought by just one of those people, that is, the lead plaintiff. To succeed against the power company in the negligence claim, the lead plaintiff had to establish that the power company owed the lead plaintiff a duty of care, and that the power company had breached that duty of care by not properly maintaining its electricity lines. If the court was persuaded that these two requirements had been satisfied, as was the case in the Black Saturday bushfire class actions, then it would not be necessary for the other plaintiffs, that is, the group members, to prove that these two legal requirements had in fact been satisfied in their individual cases. This is because these two requirements are common to the claims of both the lead plaintiff and the other group members. Of course, each of the group members will have suffered different amounts of loss. Some of the group members lost their houses, others lost their livestock, and yet others suffered physical injuries such as serious burns. Accordingly, each group member plaintiff would still have to establish the amount of the loss that they suffered because of the power company's negligence. As a matter of practice, this is something that the defendant and each group member, in this case the power company, and each group member in the bushfire class action, can agree after the lead plaintiff has won their case. It would only be if the power company and a group member could not reach agreement about the amount of loss suffered by the group member that they would need to have a court determine the amount of the group member's loss. Note that the amount of damages payable to the plaintiffs involved in the class action is not simply calculated as a lump sum that is then divided equally between those plaintiffs. Instead, the amount of damages that is paid to a plaintiff is based on the losses that have been suffered by that plaintiff, and so different plaintiffs will be paid different amounts of damages because their losses are different. You can see that the benefit of a class action is that instead of there being multiple cases against the same person based on similar facts, there is just one case brought by the lead plaintiff on behalf of the lead plaintiff and the group members. This saves the time and resources of the courts, as the court only has to deal with one case rather than with a large number of similar cases. Our first learning intention requires you to be able to discuss the appropriateness of class actions to resolve a civil dispute. On this slide, I will set out the three circumstances in which a class action will be appropriate to resolve a civil dispute. Write each of these circumstances down in your summary books. The first circumstance is that 7 or more people who have a claim against the same defendant based on similar facts must be prepared to bring the class action. Put another way, a class action will not be appropriate to resolve a civil dispute if less than 7 people are prepared to bring the civil claim, or if the plaintiffs have claims against different defendants, or if the plaintiff's claims are not based on similar facts. The second circumstance is that one of those people must be prepared to act as the lead plaintiff. Put another way, a class action will not be appropriate to resolve a civil dispute if no one is prepared to act as the lead plaintiff. As I'll explain soon, a potential disincentive for a person to act as a lead plaintiff is that the lead plaintiff is responsible for paying the costs of the class action unless those costs are paid by a litigation funder or by the plaintiff law firm, that is, the law firm that advises the lead plaintiff in the class action. This ties in with the third circumstance where a class action will be appropriate to resolve a civil dispute, which is that a litigation funder or the plaintiff law firm, that is, the law firm that advises the lead plaintiff in the class action, is prepared to pay the costs of the class action. This is because the legal costs associated with a class action are likely to be very substantial, and if a litigation funder or the plaintiff law firm is not prepared to pay those costs, then these will need to be paid by the lead plaintiff. Because the lead plaintiff will often be an individual person, they may well not be able to afford these costs. We now need to look in a bit of detail at how a class action works. You need to understand this information so that you are able to evaluate the extent to which class actions achieve the principles of justice as required by our second learning intention. As I've already explained, in a class action, one of the plaintiffs, known as the lead plaintiff, sues the defendant on behalf of a group of plaintiffs, known as the group members. The group members will be the group of plaintiffs who are described in the lead plaintiff's statement of claim. For example, if the class action is a negligence claim against a cosmetic surgery clinic where a number of people have had botched facelifts, then the lead plaintiff's statement of claim might describe the group members as all persons who have suffered loss or damage as a result of cosmetic surgery performed on them at the Brimbank Facelift Clinic during 2024 and 2025. It is often the case that the lead plaintiff does not know who all the group members are, in the sense of knowing their individual names or circumstances, and that is the reason for the plaintiff's statement of claim describing the group members as a class rather than individually. It is also quite possible that the group members themselves do not even know that there is a class action, although the existence of a class action will typically be advertised by the lead plaintiff in the newspapers. The class action will either be a class action that requires group members to opt out of the class action, or a class action that requires group members to opt into the class action. Where the class action requires group members to opt out of the class action, this means that if a group member does not want to be bound by the result of the class action, then that group member must notify the lead plaintiff that they are not part of the class action. A group member who opts out of the class action is not entitled to be paid damages by the defendant where the class action is successful, and does not get the benefit of any settlement with the defendant where the defendant agrees to settle the class action before any verdict by paying compensation to the lead plaintiff and the other group members. However, the opting out group member also does not lose their civil claim against the defendant where the class action is not successful. A group member will typically opt out of a class action where they want to bring their own individual civil claim against the defendant. Where the class action requires group members to opt into the class action, this means that a group member must notify the lead plaintiff if they want to be part of the class action. A group member who opts into the class action will be entitled to be paid damages by the defendant where the class action is successful, and will get the benefit of any settlement with the defendant where the defendant agrees to settle the class action before any verdict by paying compensation to the lead plaintiff and the other group members. However, the opting-in group member will lose their civil claim against the defendant where the class action is not successful. That is, the group member will not be able to subsequently bring their own individual claim against the defendant. While group members can choose to attend the legal proceedings relating to the class action, they do not actively participate in the lead plaintiff's case and very much take a backseat role. For example, they do not give instructions to the plaintiff law firm, and they do not give any evidence as witnesses in the trial of the class action. The plaintiff law firm is the law firm that advises the lead plaintiff in the class action. As I've already explained, the legal costs associated with a class action are likely to be very substantial. For this reason, the plaintiff law firm generally acts on a no-win, no-fee basis. What this means is that if the lead plaintiff loses their case against the defendant, then the plaintiff law firm agrees to bear its own legal costs. Conversely, if the lead plaintiff wins their case against the defendant, then the plaintiff law firm is paid a higher fee than its standard fee. For example, it might be paid a fee that is 30% higher than the fee it would normally charge. This fee will be paid out of the damages that are paid to the lead plaintiff and the other group members where the trial results in a verdict in favour of the lead plaintiff, or out of any compensation that the defendant agrees to pay to the lead plaintiff and the other group members where the defendant agrees to settle the class action before any verdict. In this way, the lead plaintiff and the other group members effectively share in paying the legal costs that the lead plaintiff would otherwise have to pay to the plaintiff law firm. And these legal costs are only payable if the lead plaintiff wins by obtaining a favourable verdict at trial or by reaching a settlement with the defendant before any verdict. The issue for the lead plaintiff is that if the class action is not successful, then it will be the lead plaintiff and not the plaintiff law firm that has to pay any adverse costs order. Given the very substantial legal costs associated with a class action and the risk that the lead plaintiff runs of having an adverse costs order awarded against them where the class action is unsuccessful, the best position is to have a litigation funder who is willing to fund the costs of the class action. A litigation funder is a company that specialises in funding class actions and that earns its money by being paid a percentage of the damages or compensation that a defendant is required to pay to the lead plaintiff and the other group members where the class action is successful at trial or is settled before a verdict. In some cases, the plaintiff law firm will act as the litigation funder. The way litigation funding works is that the litigation funder agrees to pay the costs of the class action, whether or not the class action is successful, in return for being paid a percentage of any damages or compensation paid to the lead plaintiff and the other group members where the lead plaintiff wins. That is, if the lead plaintiff receives a favourable verdict at the trial of the class action, then the litigation funder will be paid a percentage of the damages paid to the lead plaintiff and the other group members. Alternatively, if the lead plaintiff reaches a settlement with the defendant before any verdict, under which the defendant agrees to pay compensation to the lead plaintiff and the other group members, then the litigation funder will be paid a percentage of the compensation paid by the defendant to the lead plaintiff and the other group members as part of that settlement. In summary, the litigation funder pays the costs of the class action, including any adverse costs order if the lead plaintiff loses. The benefit of this is that the lead plaintiff is not exposed to any legal costs, including under an adverse costs order as a result of the lead plaintiff's class action being unsuccessful. Conversely, if the lead plaintiff wins in the sense that the lead plaintiff receives a favourable verdict at trial of the class action or reaches a settlement with the defendant before any verdict under which the defendant agrees to pay compensation to the lead plaintiff and the other group members, then the litigation funder is paid a percentage of those damages or that compensation. This percentage is the same for all of the plaintiffs involved in the class action, but obviously the actual amount that is paid by each plaintiff depends upon the amount of damages or compensation that is paid to them. According to the Australian Law Reform Commission, the average percentage of damages or compensation that is paid to litigation funders in class actions is around 27.8%. In addition, the litigation funder pays any amount of the plaintiff law firm's legal fees that is not covered by an adverse costs order against the defendant. Where the plaintiff law firm acts as the litigation funder, then it will take its legal fees out of the percentage of the damages or compensation that the lead plaintiff and other group members are required to pay to the plaintiff law firm as part of the litigation funding arrangement. This slide sets out the role of the court in a class action. Class actions are heard in the trial division of the Supreme Court and, like any civil action, the trial may be a jury trial or a judge-only trial. If the class action goes to trial, then an important role of the court is to decide whether the defendant is liable, in which case the verdict is to uphold the lead plaintiff's claim, or whether the defendant is not liable, in which case the verdict is to dismiss the lead plaintiff's claim. If the trial is a jury trial, then it is the jury that decides this verdict. But if the trial is a judge-only trial, then it is the judge that decides this verdict. Where the defendant is liable, then the court must decide the amount of damages to award to the lead plaintiff. If the trial is a jury trial, then it is the jury that decides this amount of damages. But if the trial is a judge-only trial, then it is the judge that decides this amount of damages. As far as the other group members are concerned, they must then agree with the defendant the amount of loss that they have suffered as a result of the defendant's civil wrong, and therefore the amount of damages that the defendant must pay to the group member. And it is only if the defendant and the group member cannot reach agreement about the amount of loss suffered by the group member that they would need to have the court determine the amount of the group member's loss, and therefore the amount of damages that the defendant must pay to the group member. The trial division, specifically the judge, also has an important role to play in approving key financial aspects of a class action. The court's oversight of these key financial matters is intended to protect the lead plaintiff and the other group members. First, if the class action is settled by the lead plaintiff and the defendant before any verdict, then the court must decide whether to approve that settlement. This is important to protect the other group members, as that settlement, including the amount of compensation payable under the settlement to the lead plaintiff and the other group members, is binding on those other group members. As a matter of practice, most class actions are actually settled before any verdict. This settlement can occur before the class action is brought to trial or after the class action is brought to trial, but before the court decides a verdict. Second, the court must approve the amount of legal costs that are to be paid to the plaintiff law firm. This is important to protect the lead plaintiff and the other group members where the plaintiff law firm acts on a no-win, no-fee basis, because those costs are paid out of the damages that are paid to the lead plaintiff and the other group members where the trial results in a verdict in favour of the lead plaintiff, or out of any compensation that the defendant agrees to pay to the lead plaintiff and the other group members where the defendant agrees to settle the class action before any verdict. In other words, those costs reduce the amount of damages or compensation that is available to the lead plaintiff and the other group members to compensate them for their losses. Third, where there is a litigation funder, then the court must approve the percentage of any damages or compensation that is paid to the litigation funder where the class action is successful at trial or is settled before any verdict. Again, this is important to protect the lead plaintiff and the other group members because this payment to the litigation funder reduces the amount of damages or compensation that is available to the lead plaintiff and the other group members to compensate them for their losses. And finally, the court must decide whether to make an adverse costs order against the losing party, who could either be the lead plaintiff or the defendant, and the amount of legal costs that are covered by that order. Our second learning intention requires you to be able to evaluate the extent to which class actions achieve the principles of justice. In this slide, I will take you through the features of class actions and how they both achieve and detract from the achievement of the principles of justice of fairness, equality, and access. I've given you a copy of this table, and you should include this copy in your summary books, supplementing it with notes from the discussion which follows. The first feature of a class action is that it allows plaintiffs who cannot afford to bring a proceeding by themselves, or whose individual claims may be relatively small, to have a test case, namely the lead plaintiff's case, resolved by a court. As we've seen, the lead plaintiff is legally responsible for paying the costs of the proceeding, including any adverse costs order, if the lead plaintiff loses their case. However, it is common for the plaintiff law firm to agree to a no-win, no-fee arrangement under which, if the lead plaintiff loses their case against the defendant, then the plaintiff law firm agrees to bear its own legal costs, but if the lead plaintiff wins their case against the defendant, then the plaintiff law firm is paid a higher fee than its standard fee out of the damages that are paid to the lead plaintiff and the other group members, where the trial results in a verdict in favour of the lead plaintiff, or out of any compensation that the defendant agrees to pay to the lead plaintiff and the other group members, where the defendant agrees to settle the class action before any verdict. As I've explained, this effectively means the lead plaintiff and the other group members share in paying the legal costs that the lead plaintiff would otherwise have to pay to the plaintiff law firm. Importantly, these legal costs are only payable if the lead plaintiff wins by obtaining a favourable verdict at trial or by reaching a settlement with the defendant before any verdict. This increases access in two ways. First, the plaintiffs only pay the plaintiff law firm's legal fees if the class action is successful. This facilitates the class action plaintiffs enforcing their rights and pursuing their case because it removes the risk that the plaintiffs will have to pay their legal costs if the class action is unsuccessful. And if the class action is successful, then the plaintiffs are able to fund the payment of their legal costs out of the damages or compensation that is paid to them. Second, the amount that each plaintiff has to pay as legal costs will be much less than if they brought their own individual cases and had to pay their individual legal costs. Instead, the class action plaintiffs effectively share the costs associated with the lead plaintiff's case between themselves. Again, this facilitates the class action plaintiffs enforcing their rights and pursuing their case because it makes it cheaper for them to do this. Of course, this still leaves the lead plaintiff having to pay any adverse costs order if the class action is unsuccessful, which is a disincentive for a person to become the lead plaintiff. The second feature of a class action is that where there is a litigation funder, then the litigation funder will pay the costs of the class action, whether or not the class action is successful, and will also pay any adverse costs order if the class action is not successful. This increases access by facilitating the class action plaintiffs enforcing their rights and pursuing their case, because the plaintiffs do not have to pay any legal costs at all. The third feature of a class action is that where there is a litigation funder and the class action is successful in the sense that the lead plaintiff receives a favourable verdict at trial of the class action or reaches a settlement with the defendant before any verdict under which the defendant agrees to pay compensation to the lead plaintiff and to the other group members, then the litigation funder is paid a percentage of those damages or that compensation. This is not in itself a bad thing, as the litigation funder does need to be compensated for the risk of the lead plaintiff losing and the litigation funder therefore having to pay both the plaintiff law firm's fees and the legal costs of the defendant under an adverse costs order. However, it does mean that a class action plaintiff will not receive full compensation for their loss because some of the damages or compensation that would otherwise be used to compensate the plaintiff for their loss must instead be paid to the litigation funder. This will be unfair to the plaintiffs where the percentage of damages or compensation taken by the litigation funder is relatively high. This will also detract from access because it reduces the ability of the plaintiffs to enforce their rights to obtain full compensation. As I've said, the Australian Law Reform Commission has estimated that litigation funders are paid on average 27.8% of damages or compensation as their fee. This is an average, and so sometimes the percentage is higher than this. However, the fact that the court must approve the percentage taken by the litigation funder in any particular class action does act as a safeguard and also limits the extent to which this feature of a class action detracts from fairness and access. The fourth feature of a class action is that the group members do not actively participate in the lead plaintiff's case and very much take a backseat role. This means that the group members do not have to spend time attending court and instructing lawyers. This in turn increases access because it enables the group members to enforce their rights and pursue their case without having to spend the time and without having to suffer the stress that is otherwise associated with legal proceedings. Instead, it is the lead plaintiff who has to do this. On the other hand, the fact that the group members do not have any input into the presentation of the case detracts from fairness because they are being denied the opportunity to present their own case. And it also detracts from access because those group members are unable to enforce their rights directly against the defendant. The fifth feature of a class action is that there is just one case being brought against the defendant, that is, the lead plaintiff's case, instead of multiple similar cases being brought by the individual group members. This contributes to the achievement of access in two ways. First, it reduces court backlogs because it is more efficient for the court to deal with a number of similar claims at the same time. Second, it frees up the time and resources of the courts to deal with other cases. In these ways, class actions increase the access of parties in other cases to the legal system. The sixth and final feature of a class action is that they are often conducted by experienced lawyers. This is because class actions are quite complicated and also generate significant legal fees. The fact that class actions are often conducted by experienced lawyers is important because the defendants in class actions tend to be large, well-resourced companies who can afford to engage very experienced lawyers. Having a class action therefore means that the class action plaintiffs are represented by lawyers who are well matched against the defendants' lawyers. This contributes to the achievement of equality by removing the disadvantage that the plaintiffs would have if they were not represented by experienced class action lawyers and instead brought their own individual actions against the defendant who is defended by very experienced lawyers. Well, this brings us to the end of this video. As a result of watching this video and taking notes on it, you should now be able to do two things. The first thing is that you should be able to discuss the appropriateness of class actions to resolve a civil dispute. The second thing is that you should be able to evaluate the extent to which class actions achieve the principles of justice. Please now read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, make sure you supplement your Cornell notes with that information. Thank you for your attention.